The best way to deal with an immigration mistake is to avoid it in the first place. Immigration mistakes are costly, very stressful, and in most cases can be easily avoided. The purpose of my channel is to teach you guys and share with you guys tips and information that may help you, and I hope it will help you, to avoid mistakes when you're dealing with immigration issues in the United States or outside of the United States when you're trying to file for some immigration benefits that may be provided in the United States. My name is Alena Shautsova. I'm an immigration attorney from New York, and today we're going to talk about 3 interesting cases for people who found themselves in unexpected situations after they tried to either submit their requests for various immigration benefits or sponsor their family members, and deep into the process they found out that at the beginning of the process they made mistakes. My name is Alena Shautsova. I'm an immigration attorney from New York, and in this channel, whenever I have free time from my practice, I share with you tips and information that may help you, your family members, your friends to avoid immigration mistakes that may cost people their immigration status, thousands of dollars in expenses, and absolutely unnecessary stress. So thank you very much for joining me. If you have not subscribed to my channel, please do so we can stay connected, and let's start. The first case I wanted to share with you about is of client X, who contacted me to find out what happened to client's petition that was filed for the spouse who is overseas. Apparently everything went through and I-130 petition was approved initially. However, after the interview at the consulate overseas, instead of receiving a visa, the government issued to the visa potential beneficiary 221G notice or administrative processing notice. And the case got stuck, actually got stuck for years. So the client who contacted me could not understand why and what happened and what can be done. Well, typically when you have administrative processing, you may follow up with the consulate. You can also follow up with LegalNet. You sometimes can even file a lawsuit to see what happened. But this case was different. When I started talking to the client to see what potential issues may be, I quickly discovered that it's not really the administrative processing that's a problem here. The problem, unfortunately, was much bigger. The problem was that the client was initially sponsored to the United States by a family member and entered the United States receiving a visa as unmarried child. However, what happened to this particular client, and unfortunately to many others I spoke to, that between the time the visa was issued to the client and the entry into the United States, the client did get married with their foreign spouse. So they receive a visa at the consulate, they quickly get married, and then they come to the United States using the same visa that was just issued to them. At the border, very often, the issue of their marriage is not even being discussed. So the client continues living in the United States, sometimes even travels back and forth without any suspicion that there may be a problem down the road. And that problem was exactly discovered by USCIS, not even by USCIS, but consulate, when the client decided to finally sponsor that spouse that they married before entering the United States. What happened to this client is really very sad. The visa of the client is completely invalidated and status was obtained by mistake because of that marriage in between. To deal with this problem, the client now will have to spend potentially years of in a very stressful situation, and probably thousands of dollars if the problem will be able to be fixed at all. What happens when the visa or immigrant visa or green card is issued in error in this particular case is that the government cannot approve such client's naturalization application. Moreover, very often the government is going to place such a person in removal proceedings. And believe it or not, if the person is placed in removal proceedings in this situation, this is their only chance to fix the situation and open the door to potential citizenship by filing for a special waiver, which is available only when the client is in removal proceedings. So what's going to happen next is that the client needs to either ask the government to be placed in removal proceedings, or the government has to be the first one to initiate the removal proceedings, and then the client has to hope that their waiver for this misrepresentation or error will be granted. Of course, the client also has to qualify for the waiver, and by the way, all waivers are discretionary, meaning that the judge may deny the waiver. Check this out. This whole situation, the stress, uncertainty as to the client's family situation, immigration situation, their life in the United States could have been easily avoided if the client would avoid marrying before entering the United States, would enter the United States first, convey the status of a green card holder upon themselves, and then marry their fiancé, spouse, boyfriend, girlfriend, partner. This whole situation could have been avoided. So I hope if you are in this situation, now you at least know that there is a tiny hope to fix it. And more than anything, I hope that you, or someone you know, are going to avoid this particular mistake. The second case is also interesting. It's interesting because it involves asylum seekers, dependents and principals. Why is it interesting? It's because in the United States, a lot of people receive the status through asylum. And once they do, you may be aware, once you receive your asylum as a principal, you may be able to sponsor your children who were under 21 at the time when you filed your asylum application, or your spouse who was overseas at the time when you were filing your asylum application. And you can sponsor them for asylee status by filing Form I-730. Many people do use this opportunity to unite with their family members before they become citizens or green card holders. That's a great way to do that. But what some people do not know is the following. After the principal receives the asylum status, naturally they would like to receive green card holder status. And then very shortly, or in 4 years, they would like to receive citizenship status. It's an absolutely normal desire of someone who would like to become a citizen in the United States to do everything very fast. But here is a trick, a mistake, something that you may not suspect is going to happen. If the principal, the main person who received asylum, receives their naturalization prior to their family member's green card, prior to their family members receiving their green card, the family member is no longer a dependent. And the family member will have to, rather than simply file for their green card, they will have to first submit a special asylum application with asylum office and wait for an interview for quite some time before they will be able to apply for that green card. Why? Because that's how the law works. Again, a tiny mistake. The principal receives naturalization prior to his or her dependents receiving green card, and it causes huge trouble. Easily avoidable, especially if you work with an attorney. An attorney can really help you out here. But now you know about this mistake as well, and hopefully you will avoid it too. And finally, I would like to talk with you about one more situation that I see quite often. I mentioned that situation in my previous videos, but I think it's worth talking about it here again. When you're filing for adjustment of status in the United States government has absolute access to all of your previous applications, petitions that were filed for you on your behalf or by you. It includes visa applications. So what I see, especially recently, quite often, that people who are trying to receive green card or adjustment of status based on marriage are sometimes facing difficult situation when the government accuses them of fraud. Why? It's because during their visa application, the non-citizen mentioned that they were married in their home country. And when they're filing for adjustment of status, they do not mention that marriage because they were never married. They are trying to say sometimes that that misrepresentation was about actually common law marriage, or perhaps someone else made this mistake for them, like a travel agency that filled out their paperwork for them. Or sometimes they present an argument that that relationship was just a boyfriend-girlfriend relationship and they're not even aware why it says on the paperwork that they were actually married to the person. I'm going to tell you that this is quite a common situation. Regardless of who made this mistake and why, chances are you will be charged with misrepresentation or fraud in this particular situation. And as a result, you will need a very costly waiver, which again may or may not be granted, because to qualify for a waiver related to misrepresentation or fraud, you will have to first have a qualifying relative, then establish extreme hardship to that relative, and then of course the waiver has to be granted in a matter of discretion. What can you learn from this situation? When you're filing for that visa, make sure to provide accurate information, even though that knowing that if you do so, your visa application may be denied. Because if you box yourself into this situation saying that you have a child that never existed or a spouse that never existed, later on you will be charged with misrepresentation or fraud under the United States immigration laws. It's much easier to simply avoid this mistake. Thank you very much for watching. I hope you find this video interesting. Please like and share it. Don't forget to join my channel, and I hope to see you soon.